Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 276C, which talks about willful attempt to evade the tax. The issue was that if the assessee files revised return of income with increased tax liability but is not able to deposit the tax within time or with the revised return of income and deposits the tax suo motu after some time, so whether this case fits into the definition of willful attempt to evade the tax. This issue has been decided by Punjab and Haryana High Court in the case of Health Biotech Limited and others versus Deputy Commissioner of Income Tax. The matter has been reported in 459 ITR at page number 349 and the date of the judgment is 14th September 2023. In the present case, the facts are like this. The assessee filed its return of income, paid the self-assessment tax. After some time, the assessee felt that there is some mistake and the assessee revised his return of income with the increased tax liability, but the assessee was not able to deposit the tax with the revised return. But the facts of the case are like this, that the assessee deposited the tax suo motu. After some time, the interest was paid, the penalty for late deposit was levied, and the assessee also deposited the penalty. But after some time, Deputy Commissioner of Income Tax initiated prosecution proceedings under section 276C, which talks about willful attempt to evade the tax, and under section 278B, that talks about the offences by the companies, and the summoning order was issued by the magistrate. The assessee filed the petition in the High Court for quashing this prosecution proceedings, and the Punjab and Haryana High Court said that in the present facts and circumstances, when the assessee has suo motu filed his revised return of income and paid the tax after some time, although it was not paid with the return of income, then it cannot be said that there is any attempt to evade the tax on the part of the assessee company. The court said that there is undoubtedly delay for the payment of the tax, but for that penalty has already been paid, and the court said that from the very beginning there is no intent in the mind of the assessee to evade the tax from the very beginning. The court also said that for initiating the prosecution proceedings, there should be willful attempt or there should be some default of evasion of tax. Then the prosecution proceedings under section 276C, that talks about the willful attempt to evade the tax, and 278B, which talks about the offences by companies. The nutshell of this case gives the impression that if the assessee suo motu revises his return of income, due to which his tax liability increases and which the assessee deposits by his own, so whether this delayed payment can come into the terminology of the willful attempt to evade the tax. So the court was very clear and said that from the very beginning there was no intent of the assessee from the very beginning to evade the tax. So it cannot be said that the assessee has some bad intention for delaying the payment of the tax or for non-deposit of tax. So in the present case, the Punjab and Haryana High Court quashed the prosecution proceedings, the summons which was issued by the magistrate. Friends, the conclusion and the takeaway from this case is that the department is in a very hyperactive mode, and the department do not miss any opportunity to harass the assessee, especially when the harsh provisions like prosecution that should be only adopted and those provisions should only be used by the department in the cases where there is some very grave and very intense mistake by the assessee, or the assessee has made some very harsh evasion of tax. In the lighter modes, in the lighter mistakes, in the lighter errors, this provisions should not be initiated against the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Health Biotech Limited and others versus Deputy Commissioner of Income Tax, and this case has been reported in 459 ITR at page number 349. The matter has been decided by Punjab and Haryana High Court, and the date of the judgment is 14th September 2023. Thank you, friends.